Bonjour, Kinamagin in Ireland Indigenous, and welcome to this edition of Social Studies Explorer. Today's episode, You the Jury, the Boston Massacre. Over the course of the last several sessions, we've been talking about events leading up to the Revolutionary War. In particular, we've been discussing the Boston Massacre. We had the opportunity to read from the Michigan Open Book, which included links to videos that suggested the British were at fault and videos suggesting the colonists were at fault. We've watched a video from Unsolved History breaking down some of the truths and untruths of that day. And today we're going to get some information from famous trials and legal documents and whatnot that will provide some more information about the views of Captain Preston and some of the other persons located at the heart of the event. Once I'm done reading this to you, we'll return to the Google Classroom and you'll have the opportunity to answer the question of who it was at, what was the lead up, and who was at fault. Here we go. A week after the massacre, at the request of Attorney General Jonathan Sewell, a grand jury handed down indictments against Captain Preston and 8 soldiers. About the same time, Preston offered his version of the events of March 5th in a deposition. And a deposition is a recorded statement of what happened. In this case, recorded would have been by hand notes in not like a digital recorder. About 9, some of the guard came to and informed me the town inhabitants were assembling to attack the troops, and that the bells were ringing as a signal for that purpose and not for fire. And the beacon intended to be fire to bring in the distant people of the country. This, as I was captain of the day, occasioned by repairing immediately to the main guard. In my way there, I saw the people in great commotion and heard them use the most cruel and horrid threats against the troops. In a few minutes after I reached the guard, about 100 people passed it and went towards the custom house where the king's money is lodged. They immediately surrounded the sentry posted there and with clubs and other weapons threatened to execute their vengeance on him. I was soon informed by a townsman their intention was to carry off the soldier from his post and probably murder him, on which I desired him to return for further intelligence, and he soon came back and assured me he heard the mob declare that they would murder him. This I feared might be a prelude to their plundering the king's chest. I immediately sent a non-commissioned officer and 12 men to protect both the sentry and the king's money, and very soon followed myself to prevent, if possible, all disorder, fearing lest the officer and soldiers, and by the insults and provocations of the rioters, should be thrown off their guard and commit some rash act. Jail cell writings of Preston appeared in the Boston Gazette. In an early letter to the paper, Preston extended his thanks to the inhabitants of this town who, throwing aside all party and prejudice, have turned with the most utmost humanity and freedom step forth advocates for the truth in defense of my injured innocence. On June 25th, however, a letter Preston sent to London found its way into Boston papers and undermined whatever goodwill he might have built up earlier. In his London letter, Preston complained about Bostonians who have ever used all means in their power to weaken the regiments and to bring them into contempt by promoting and aiding desertions and by grossly and falsely promulgating untruths concerning them. He wrote that bitter malcontents were maliciously using every method to fish out evidence to prove the March 5th shooting was a concerted scheme to murder the inhabitants. Although the trial was transcribed in shorthand, no copy survives, and Preston's testimony must be surmised from the deposition he gave in advance of trial. In Preston's deposition, he offered the following account of the actual shooting. Some well-behaved persons asked me if the guns were charged. I replied yes. They then asked me if I intended to order the men to fire. I answered no, by no means, observing to them that I was advanced before the muzzles of the men's pieces, and must fall a sacrifice if they fired, that the soldiers were upon the half cock and charged bayonets, and my giving the word fire under those circumstances would prove me to be no officer. While I was thus speaking, one of the soldiers, having received a severe blow with a stick, stepped a little on one side and instantly fired. On which, turning to and asking why he fired without orders, I was struck with a club on my arm, which for some time deprived me the use of it. Which blow, had it been placed on my head, would have destroyed me. On this, a general attack was made by the men by a great number of heavy clubs and snowballs being thrown at them, by which all their lives were in imminent danger. Some persons at the same time from behind calling out, "Your bloods, why don't you fire?" Instantly, 3 or 4 of the soldiers fired, one after another, and directly after 3 more in the same confusion and hurry. Of particular interest in the defense case was testimony concerning the dying statement of Patrick Carr, one of the victims in the massacre. It is the first recorded use of the dying declaration, exception to the rule that excludes hearsay evidence. "Was you Patrick Carr's surgeon?" "I was." "Was he apprehensive of his danger?" "He told me he was a native of Ireland, and he had frequently seen mobs and soldiers called upon to quell them. He had seen soldiers often fire on the people in Ireland, but had never seen them bear half so much before they fired in his life." When you had the last convers when had you the last conversation with him?" "About 4 o'clock in the afternoon, preceding the night on which he died. And he then particularly said he forgave the man, whoever he was, that shot him. He was satisfied he had no malice, but fired to defend himself." After presenting over 40 witnesses, John Adams summed up for the defense. His eloquent speech blended law and politics. He finished by telling the jury that this was a case of self-defense. "I will enlarge no more on the evidence, but submit it to you. Facts are stubborn things. In whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence, nor is the law less stable than the fact. If an assault was made to endanger their lives, the law is clear. They had a right to kill in their own defense. If it was not so severe as to endanger their lives, yet if they were assaulted at all, struck and abused by blows of any sort, by snowballs, oyster shells, cinders, clubs, or sticks of any kind, this was a provocation, for which the law reduces the sentence of killing down to manslaughter. In consideration of those passions of our nature which cannot be eradicated, to your candor and justice I submit the prisoners and their cause." Justices Trowbridge and Oliver instructed the jury. Justice Trowbridge told the 12 men of Boston that malice is the grand criterion that distinguishes murder from all other homicides. Justice Oliver discussed Patrick Carr's dying statement to his physician. "This Carr was not upon oath, it is true, but you will determine whether a man just stepping into eternity is not to be believed, especially in favor of a set of men by whom he had lost his life." After less than 3 hours' deliberation, the jury acquitted 6 of the soldiers on all charges. Hugh Montgomery and Matthew Kilroy, the only 2 soldiers clearly proven to have fired, were found guilty of manslaughter. On December 14th, Montgomery and Kilroy came into court. Asked if there was any reason why the sentence of death should not be passed, the 2 men invoked the benefit of clergy, a plea that shifted their punishment from imprisonment to the branding of their thumbs. As John Adams looked on, the men held out their right thumbs for Sheriff Stephen Greenleaf to brand. At this point, you have now seen all the evidence that will be presented to you. You're going to retire to your own minds and decide who was at fault. It is okay if you discuss it with other students before coming up with an answer, or even in your own household. But when this is done, your assignment is to fill out the Google form. You're going to decide who was at fault, and you're going to give me a reason. Part of that will be what events led up to it and what was the effect. You are allowed to use any of the materials that were presented in this class as part of your evidence. I look forward to seeing what you guys have thought. and then comparing it to what other teams of jurors in past years have thought. Vi all have a Minogishagad, Minwa, Bama P.